Hi, this is Mark Sokolow, and today we're going to talk about contracts and the terms in contracts, and then we're going to study industrial district agreements and specifically an agreement between the City of Port Arthur and Total for the deep conversion project refinery expansion. This involves an incentive agreement with approximately $26 million in revenue for the City of Port Arthur and involved a $2 billion plant expansion. Now, first off, let's go over just the basic parameters of what contracts are all about. The purpose of contracts is that it's a blueprint for success. You negotiate an agreement, and both sides should want that the agreement is successful. To do that, you want to document the deal, make certain that all the aspects, the specifications are documented. You want to allocate costs for contingencies, change orders. You want to delineate procedures for disputes. In terms of how long the agreement is going to be, it really depends on the experience of the parties. Some agreements are just a few pages long. Other agreements, which in this case is probably 10 to 20 pages long, if not longer, covers just many more details. The title of the agreement, usually the very first page, shows that it's an agreement. The agreement shall list the parties, usually it's in the preamble, that are bound by the agreement, that's signing off the agreement. It usually tells you who the entities are they a corporation, are they a partnership, is it a municipality? Many times the parties sign the agreements at different times, but they put an effective date when the agreement is going to be effective, how long the agreement is going to last. In this case, when we get to the incentive agreement Total, the agreement is from 2009 to 2021 with extension terms. Description of the goods or services to be provided. In this case, it's going to be about the incentive that's being given to Total to build a plant expansion in the City of Port Arthur. Force majeure clause, that's just a clause in case there's a hurricane, an event outside the control. Deadlines would need to be extended, and you just discuss it. As to where the goods or services are going to be delivered. Price. If you are selling goods or services, how the price is going to be determined. In this case, we're actually going to be talking about industrial district agreement payments from Total to the City of Port Arthur. Payment terms. Are they up front? Are they in progress payments? Are they paid after the service is rendered? Change orders. That usually deals with construction, changes in scope or price. Warranty, this is usually dealing with construction. It can also be dealing with professional services. Construction is usually warranted for 1 year from day of substantial completion of the work. Sometimes when you're dealing with professionals, they may ask for their liability to be limited. Insurance, you can ask your contractor to have liability insurance. In construction agreements, sometimes you ask for performance bonds or payment bonds. Performance bonds, sometimes is issued by companies like by Travelers or Safeco. It's to ensure that the work is completed. Payment bonds is designed for the subcontractors to be paid. Indemnity clause, you'd say you're asking someone to build a building. The contractor will indemnify you if it causes any damages during his construction activities. Venue, that is simply where, if there's litigation, where is the litigation going to take place? You may have a Harris County company doing business in Jefferson County. They can negotiate where the litigation would be, whether it be in Jefferson County or Harris County. In a dispute, you may want to go to mediation, which is just simply an organized settlement conference with a facilitator. And in your agreement, you can discuss how the mediation costs are going to be split. As an alternative, you may want to say, if there's a dispute, you want to go to an arbitrator. The American Arbitration Association provides panels of arbitrators. They'll usually provide a panel of about 7 people, give you their backgrounds, and then each party strikes from the list until they get to one arbitrator. And then you present evidence at a hearing before the arbitrator, and the arbitrator issues a ruling. Now, you can also, you'd say you're doing business with a Louisiana company, you can decide which laws are going to be applicable. Is it Texas laws or Louisiana laws? In agreement, a party may reserve the right to terminate the agreement without cause, or can terminate the agreement with cause. An entire agreement clause, all that is, it just simply says that this is the entire agreement. It supersedes anything else, any other agreements, any other oral comments. Independent contractor clause, all that is simply saying that the other party is an independent contractor and is not an employee. Now, there are tax implications. If a person really is an employee, simply by calling them an independent contractor won't cut it with the IRS. Assignment clause. In these industrial disagreements, we had assignment clause. Basically, they can assign it to a qualified third party upon the written approval of the city, which will not be unreasonably withheld. Severability clause. I call this the oops clause. That's a situation where you have a revision in the agreement or a clause which may not have been legal, or you'd say as time goes by, the legislature comes out with a law that says that particular type of clause is not legal anymore. Well, a severability clause says, okay, you delete that one clause and the rest of the agreement's still good. Undocumented workers clause. In Texas, you now need these type of clauses for incentive agreements, that the company that receives the incentive cannot employ undocumented workers. A notice of default clause, someone messes up and you simply say, look, if you're in default, we'll give you 10 days notice and give you a chance to cure the default. Delay damages clause. That's a provision. You'd say you have construction, you gave them 300 calendar days to complete it, they don't. So you charge them $500 per day liquidated damages. Now you can have revision in your, instead of having calendar days, you just say regular days, and if there's a rain day, then it's automatically extended for the amount of time of the rain. Then of course you have the signature lines. Agreements need to be signed. You want to make certain that you sign it on behalf of, if it's a corporation, on behalf of the corporation and not in your individual capacity. Now in our next step, we're going to study the industrial disagreement that was signed between the City of Port Arthur and Total for the deep conversion project refinery expansion. This was a $2 billion refinery project. In this case, the agreement is actually approximately 47 pages. You can locate the agreement at the City of Port Arthur website. It was approved by Resolution 08-474 on December 16, 2008. The title of it is, of course, Industrial Disagreement with Total Petrochemicals USA and Total Par LLC Deep Conversion Project, and the term of the agreement is from 2009 to 2011. In the very beginning of the agreement, we kind of go between the history of the parties. Originally, it goes back to, it talks about the existing agreements that the city has, in this case with Adofina, where they're paying the city over $2,250,000 per year, and from 2000 to 2008. What you're basically looking at in this agreement is an expansion and also a new program that was instituted by the City Council called Local Business Enterprise, because what they really were interested in was, of course, they wanted the refinery to take place, but when you have $2 billion in construction dollars, you want the companies to try as much as possible to hire Port Arthur companies and contractors. Here you can see that the project's called the Deep Conversion Project, and the City Council is interested in maximizing job opportunities and contracting opportunities for Port Arthur residents and Port Arthur businesses and contractors. And it's going to be working with Lamar State College on this project. They are looking at enhancing opportunities for minority and women-owned businesses. This agreement talks about what amounts of money that the Total is going to be paying the city of Port Arthur. Now, in this case, what's happening is that Total is in an area of land that is in the city's extraterritorial jurisdiction. The extraterritorial jurisdiction is land that is either adjacent to the city or next to the city that they can annex. And what the city is promising to do is that during the pendency of this agreement, it will not annex this refinery so long as the company pays them money and abides by this agreement. So for the first agreement portion of the property, the first year the company doesn't have to pay the city anything for the new project because, of course, the project is in the process of being constructed. So for 2009 through 2011, Total is not paying the city any money. Starting in 2012, you can see the payments. On October 15, 2012, Total will pay the city $500,000. On October 15, 2013, Total will pay the city $930,000. In October 15, 2014, $1,450,000. And then you see the amount of money is escalating all the way to $4,250,000 per year on October 15, 2021. So the city is basically receiving over $26 million from Total. And in return, the city is agreeing with Total that it will not annex this piece of property. Now, these payments are in addition to any other payments that Total is making under any other industrial disagreements for the existing portions of the plant that are there. Now, this provision right here is that the city will not refund or credit any other in lieu of tax payments that have been previously been paid. Now, we had certain health and safety provisions. Of course, refineries can be dangerous. And in this case, if requested orally in writing by the companies, the city's fire department may, in their sole discretion, provide backup fire suppression support. But, of course, we do expect the company Total to employ or provide sufficient primary fire suppression support to put out fires and chemical releases. The Total will also provide the fire chief and police chief with emergency response plans, and this involves chemical releases, hazardous, any type of chemical release, fires, things of that sort. And if there is a fire and the city is requested to provide fire suppression services, or if a cleanup is required, then Total will have to pay the city the cost, pay the city of Port Arthur the costs and expenses incurred by the city in responding. So there's a health and safety aspect to this. The city wants to make certain not only that we get a planned expansion, but we're also concerned about safety, and we want to make certain there's provisions in the agreement pertaining to it. This is notification. The company will immediately notify the Central Dispatch Office of all incidents involving fires, serious injuries, deaths, chemical releases, and flooding that create a health and safety hazard. Furthermore, the city reserves the right to annex the property for health and safety reasons. Now, this provision is annexation due to legislative action. Presently, when this was entered into, the city had extraterritorial jurisdiction and we can annex the plant. If it ever turned out sometime in the future that there was legislation that limited those rights, what this does is it still obligates the Total to continue to pay the city of Port Arthur. This is a provision on lessees that for some reason they have other improvements in the plant, then we expect them to pay the city based on valuation thereon. We do expect if for some reason they have other lessees or owners in the plant and that they have property, that those other companies need to have an industrial disagreement as well. We have an assignment clause. If they want to assign it, they have to get the city's consent, which will not be unreasonably withheld. We do expect information on the assignee. Here's an inspection paragraph. Total is agreeing that representatives of the city can inspect the property to determine compliance with the agreement. Now, there was a group called the Port Arthur Industrial Group in the city of Port Arthur. And what we're requesting Total to do is to participate in this Port Arthur Industrial Group in order to improve employment opportunities for Port Arthur residents. And we expect the Total to encourage its contractors and subcontractors to establish and fund apprenticeship, internship, education, and our mentoring programs for the training of Port Arthur residents. And then we get into the local business enterprise program. And the local business enterprise program is basically Port Arthur businesses, in that we're trying to get them to hire local businesses for this project. And of course, those businesses have to be qualified. We expect them to use their good faith efforts, commercially reasonable efforts to further in this endeavor. And then we get a little bit more specific as to what we expect from them. Good faith efforts would be arranging solicitations, times for presentation of bids, in ways that facilitate LBE participation, carrying out information communication programs on contracting procedures, letting people know when there's jobs out there. We also expect them to pay the prevailing wage as reasonably set by the city in accordance with Chapter 2258 of the Texas Government Code. We're looking at using an independent source, the Mark State College, to certify local business enterprises. And these are businesses that have been at least in the city for at least 6 months. They're for profit. And the business is expected to satisfy qualifications specified by the companies. The companies, including Total, will notify the following people of job openings: City of Port Arthur News, Texas Workforce, the Mark State College, PISD, that's the local high schools, the local labor unions. The companies will make good faith efforts to request that its major prime contractors obtain qualified LBE bids and to arrange some subcontracts by size and type to improve the opportunities for LBEs to participate. That means kind of breaking them up so that smaller companies can participate. So what you see in here is not only that we're trying to attract a large refinery expansion, but we're also trying to get jobs and contracting opportunities for Port Arthur residents and the businesses. We set up a grievance board, and the grievance board will hear grievances by Port Arthur businesses who claim that it's sought to be employed by the company and were not given a due opportunity. And we delineate procedures for the grievance board and time deadlines. We're asking the company from 2009 through 2021 to provide semi-annual reports as to their hiring of Port Arthur residents and contractors. Total number of hires by zip code, and not only by them but by the prime contractors, and the number of local business enterprises that they're hiring. So in this agreement, we really tried to get as much as possible an impetus on them hiring locals if we could. And of course, this was a $2 billion refinery expansion. There was a lot of money at stake. The city reserved the right to hire and contract for a monitor and inspect the company's records and hiring practices. Here's the provision on undocumented workers, which is required now for incentive agreements, that they simply will not hire undocumented workers. This is where they're going to start giving us information on their property tax information. Now this is, we also wanted information as to electrical consumption usage, because if they were in the city of Port Arthur, in the actual corporate limits, we would get franchise fees based on their electrical usage. So being that they have an industrial district agreement, they don't have to pay that, but they're going to be paying us approximately $26 million. We have a notice of default provision, where if we think they're in default, we have to give them at least 5 days notice, and they have an opportunity to cure. The entire agreement clause, if this is the entire agreement, it supersedes any other prior understandings. A severability clause is next if one term turns out not to be legal. A governing law clause, of course, we're saying the laws of Texas apply, and this agreement is to be performed in Jefferson County. Here's a paragraph. When you have to send notice to people, you go ahead and list their addresses. The term of the agreement is from January 1st, 2009 and shall expire on December 31st, 2021 unless it's extended by the city. And then you have the signature clauses. As you see, you got the company's name and it's by. Nobody's signing it in their personal capacity. They're signing on behalf of the corporation. And this is a great example of an industrial disagreement, and it was very successful. And if you want to get more information on the Total deconversion project, you can go to their website and see a beautiful picture of the refinery expansion.